Hey, 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 my Pontiac people. Welcome back. This is our final lesson on the Constitution and Bill of Rights and how we manage things with amendments. Today, we're talking about the flexible framework of our Constitution. In this, we really want to look at the Supreme Court and then a few specific cases. Now, the framers of our Constitution, the people who sat down and created this thing, outlined many of the principles that guide our nation, but they didn't say how these principles specifically applied to legal cases. That they left up to our court system, and most importantly, the Supreme Court of the United States. They wanted to find out, the framers wanted to leave it to the Supreme Court to determine if the government was following these basic principles within the Constitution. So it is the Supreme Court that determines the constitutionality of our government's actions. So how do we interpret a principle? Well, the interpretation of the principles of our government change over time. It changes based upon the society that we're living in and the values and morals of Americans. Because of this, future Supreme Courts may disagree with and overturn past Supreme Court rulings. Supreme Court rulings are not final. They can be changed by future Supreme Court rulings. We're going to look at the most famous example of this. In the issue of equality versus segregation in the United States, the Supreme Court has disagreed with itself. In 1896, the Supreme Court of the United States decided that segregation, that is, separation of people based upon their race, did not interfere with the 14th Amendment's clause for equal protection of the law, that all people would be protected equally. Supreme Court said we can have equal protection where people are segregated. We can have separate but equal. And that was what the Supreme Court decided in that 1896 case of Plessy versus Ferguson, that we could have separate but equal facilities. Now, obviously, this did not happen, and this is a very famous photograph, but you can see many versions of this. The white refrigerated drinking fountain versus the colored non-refrigerated drinking fountain. It's just one of those real stark examples. Now, this inequality was very clear. And one place where it was a severe problem was in schools, where the newest buildings with the newest textbooks with the best lighting and all that was always going to the white schools. And the colored schools would get torn up, old, out-of-date textbooks in buildings that had mold and crumbling masonry. So in 1954, Thurgood Marshall, this guy right here, superhero Thurgood Marshall, who was at that time a lawyer for the NAACP, that's the National Association for the Advancement of Colored People, successfully argued for the desegregation of schools because of their unequal status. It was a case where the Supreme Court was able to look at it and pretty easily determine that separate but equal was not working, and it was a violation of constitutional rights. This was in the famous Supreme Court case of Brown versus the Board of Education of Topeka, Kansas. The Brown case set off a series of reforms which outlawed all segregation and eventually led to the Civil Rights Act of 1964, where all segregation in public spaces was outlawed throughout the United States. Do keep in mind this is in public spaces. In private spaces, segregation can still happen. Affirmative action laws were passed in the late 60s to ensure that companies hired and universities admitted more African Americans. Now, the intent of this was to kind of undo past damage that had been done to African American communities. By not providing them an equal education, you hadn't provided African Americans with equal opportunities. So we're going to counteract that with affirmative action, where companies and universities had to bring in more African Americans. This, however, runs into its own legal challenge. In 1974, Alan Backe, I think I'm mispronouncing that name, Alan Backe, I'm not sure. Well, anyway, he was denied entry into the University of California despite having higher scores than African Americans who were admitted. So Allen was a white man, and he was denied admission to this school that had been admitting African Americans who tested lower than he did. So based upon those test results, Allen should have been entered. And he argued that the only reason why he wasn't admitted into University of California was because of his race. And the court ruled that that was true, that he had been discriminated against, that the policies at University of California had looked at race as a factor. And that was kind of against what all of these reforms had been, that we shouldn't be measuring people based upon their race. Now, women inequality. America has more women in its workforce than ever before. The number of women is approaching the number of men in the workforce for a number of reasons. This has led to increased concerns about the equity of women at work. This is a very famous figure, which really hasn't changed in quite some time, that when a man and a woman are in the workforce doing comparable work, for every dollar the man is paid, the woman is paid 77 cents. There are all kinds of factors that go into that, but one of them is just plain and simple sexism. Frequently, women are just paid less or not hired to do jobs that pay more. There is that inequality in our system. Ida Phillips also helped us to uncover additional problems. She had applied for a job with a company that screened out female candidates with young children. Phillips had 2 preschoolers at the time, so she had 2 young children at home. The company's thought was, she's got 2 young children at home, those kids are going to be sick, she's going to have to take sick days to take care of her kids. She's not going to be able to come in early, she's not going to be able to stay late. Those kids are going to impact her job performance. But they hadn't done similar screening for male candidates, so she filed a lawsuit. And she won her lawsuit because the company had one hiring policy for women and another one for men, and that was discriminatory. You cannot discriminate based upon based upon a person's gender. So what does all this mean? Well, what this goes to show us is that the framers of the Constitution, those people who wrote this Constitution back in a world that had slavery, where only white male property owners over the age of 21 could vote, it just means they never foresaw the world would change this much. But they did foresee that the world would change. So they had built into the Constitution the flexibility for the Constitution to change over time. They didn't foresee racial equality. Even those who wanted to end slavery did not foresee full equality. They didn't foresee women having the role that they have in the workplace today. They didn't foresee a society that would have racial discrimination against white people. Those were not in their minds at the time. But the Supreme Court of the United States, with the powers granted to it by the Constitution, helped our nation to adjust to these changes and find solutions to problems that were unforeseeable 230 years ago. And they will continue to do so because of the flexibility and the changeability of our laws and our Constitution. Thank you for joining me today. I hope you enjoyed this lesson, and farewell.